So I've been in the industry since the late 90s. I've worked for various games companies. I've also worked in legal firms, and I've done business development, and I've done legal work. And recently, I set up my own business and legal consultancy called Navatron. And that's actually my gamer tag, if anybody wants to know, but anyway. So I do business services, help developers with finding funding, business development. They want to get a license, that kind of thing, partnerships. But also I do legal services. I'm a qualified lawyer, and I've been practicing for many, many years. So that's me. So just a little disclaimer. This is the sort of legal part of my being. This presentation is just for general information. It's not to be taken as legal advice. And because we're in Poland, I think that's what that means. So if anybody's offended by what I've just said there, because I have no idea, please say. Right. So on to more serious things, but actually fun stuff. So the main thing to remember when you're making games is that games are a form of intellectual property, and intellectual property is the key aspect of knowing where your value is, because legal systems understand intellectual property. They're not tangible things, they're not physical things, but they are creative things of the mind. So if we break down what intellectual property is in respect to your game, it's things like your code, your artwork, your music, text ideas, game mechanics, characters, story. All of these things have value. That's your intellectual property. Make sure you understand that that's where your value is. I mean, some of this stuff you guys probably already know, but it's good to sometimes look back and think about these things in more depth. So you have your intellectual property, and what the law does, it gives you rights in relation to that intellectual property. So these rights are there to obviously give you value so that you can exploit your IP. But they're also there to stop other people infringing your IP, taking your ideas, taking your artwork, taking your code, and that's what they're there for. So by understanding intellectual property, you understand the value in your games, because when you do any kind of deal with someone, it's probably a licensing arrangement, there could be an assignment of IP, it could be a distribution arrangement. You can carve out certain rights. So intellectual property rights are very important in terms of your games. Now it's all gone blank. Okay, so if we break down what these intellectual property rights are, how does the law recognize them? They put them into certain categories. For example, copyright, trademarks, patents, design rights, confidentiality. These are the things that the law around the entire world have recognized, and not exactly in the same way, but in most of the ways they're very similar. So here in Poland, recognition of copyright, trademarks, patents, it's similar to other jurisdictions as well. There are slight differences, maybe sometimes in process, but there are a lot of unifying treaties and conventions which have recognized these rights universally across the world. So I'm having some problems. Oops. I've gone too far. Sorry, guys. Could you go back a couple of slides? I think this, I just want to apologize. I had a problem with my laptop earlier on, and we're trying to, could you go back one more slide? Sorry, I'll have to do this manually. So if we put the various rights into categories and classify them into how this represents the content in your game, then you can see how they work. So copyright deals with things like graphics, your code, your music. Patents deals with, trademarks deals with game names, game logos, developer names. And patents deal with things like inventive game design, technical innovations, and hardware innovations. And patents is a really interesting one, because what you'll discover as this presentation goes on what the law tends to say, particularly with copyright, and which is the main aspect of what protects computer games, is that there is a distinction between the ideas that you have and how you express them. And the only way that you're going to capture an idea and get a monopoly on an idea is through a patent. But patents are very expensive, time-consuming, and normally software-related patents aren't granted. Do you want the next slide, please? Intellectual property rights cover a vast area, and sometimes there are other things which are attached to what we term intellectual property rights. So we have areas like confidentiality, and a lot of you probably have come across this. From the start of any kind of negotiation, you have an NDA, you have a confidentiality agreement. So sometimes you need to protect things because they fall within information which you don't want to disclose before it becomes expressed, before it becomes a technical effect on an idea. So you protect those through confidentiality arrangements. And then you have things like moral rights, and a lot of people probably don't realize that these exist, but they usually attach as a subset to copyright. And you'll see some examples of where moral rights have actually been talked about in courts, and people have actually litigated again on these points. Next slide, please. So let's start with code. We always start with code. We're making games, so let's start with code. Now, code is mainly protected through copyright protection. The key thing to remember about code is when you're working with anybody externally, make sure you have an assignment of the intellectual property rights, including the code. And most legal systems recognize the fact that this assignment has to happen. You can't assume that somebody, because they're working for hire, that actually means that the person who has hired them has the rights to that code. Some jurisdictions do recognize that, but they do that with certain formalities. However, for example, in the UK, you will have to get a formal assignment of the code to you. And also have an indemnity in these provisions, to say that and it can happen, people are working away on some code, they see something on the internet, think, oh, that's an interesting bit of code that I could use. So if someone does come after you, you can go against them through the indemnity, where they have to make good all of the losses you suffered, including your legal fees. Now, the other interesting thing about code is, and I've seen this over the years, is that things get left in code. Sometimes that stuff can be quite dangerous, and we saw that with, everybody's probably familiar with Grand Theft Auto, and the scandal involving hot coffee, where there were certain aspects of the game where were far more controversial than probably most games before them, and in the end they decided not to use those aspects. However, certain very clever people managed to unlock these things, both in the PC version and in the console version. And this led to various class actions against them, etc. But that's just a lesson for you, just knowing that, yes, you can have your code, but make sure you know what's in it. Sometimes people put things in code within the sort of text where they will say things about their employers. I've seen that happen as well. So there could be libelous things that people put in. So code isn't just the collection of ones and zeros. It can be more than that. Next slide, please. So when I said earlier on that mostly code is, most IP related to games, is mainly in copyright. However, with ideas, you can get protection in patents, and they're very rare. But there are examples in the games industry, and there have been some really interesting examples. Many years ago, I was working at Codemasters. We did lots of racing cars. The big issue there was always making sure that we didn't infringe the Atari Ghost patent. Everybody probably knows that, when you race a car and then your first lap is then replayed back. Well, Atari had, or what became Midway, had that patent. Koei have a system in their Dynasty Warriors games, which is patented, to do with group battling. But one of the most famous cases involving patents was Sega against Fox and EA. And this involved Crazy Taxi. And you see Crazy Taxi, most people probably know Crazy Taxi. Crazy Taxi had a patent relating to that pointer at the top that you can see, and also a zone around the car. So as the taxi approached various characters on screen, there was a zone which was near them, which meant that the characters which were near would jump away, and the zone which was further out was characters, as they came towards the car, would slow down. And what probably didn't happen in this case was someone hadn't really checked what patents were around, and they created Simpsons Road Rage, which had a very similar system. Expressively, it's different. You know, we've got a hand now as the pointer. They had a different car, it's a different setting, etc. But the thing that bothered Sega was the fact that they'd actually done things which were against the patent. So in the end, there was a settlement. Next, please. Now, graphics. So we looked at code. What about graphics? Now, graphics is the biggest area of all, obviously. And I get a lot asked by many people, what can we put in the game? You know, what can we put from the real world? That's usually what the question is. So let's start with buildings. So buildings are considered as artistic works in most, most of the jurisdictions around the world. And buildings have this aspect of being in the public display. So if they're in the public display, generally most legal systems say, fine, you can recreate that building. What you've got to be careful about is if you go inside the building and there are things within the building, then it's making sure that you've got the permission to actually enter. So this building itself, you know, you've got the authority. Usually that's done through a location agreement. Here's an example of where the law is, you know, on one side, but also there's some controversy, because what happened was, everybody's probably familiar with the Resistance Fall of Man. Well, the cathedral in Manchester was depicted in that game. And there was this quite a lot of noise that this generated. It even went up into the House of Commons. The Prime Minister even got involved. It was that big. I mean, it was to do with the fact that obviously they'd created this cathedral in a city where there was some issues about gun violence and gun crime and things like this. However, from a legal perspective, there was nothing that they could do. However, it did generate some bad press. But the strange thing is, in this case, the sales of the games actually increased. So sometimes, you know, bad news can be good news. Next slide, please. So we've looked at buildings. What about sculptures? You know, things are out there. There's probably a lot of sculptures in Krakow, a very historic place. Sculptures are protected as artistic works. A lot of these sculptures obviously are quite old, so there's not an issue. So for example, the Statue of Liberty was created many, many years ago. However, what happened in this case was the post office in the US wanted to issue some brand new Statue of Liberty stamps. So they went to Getty Images, which is an image bank, and got a license. And people do this a lot. They think, right, I've got the license from the image bank. That means it's fine to use whatever I've got. If it's a celebrity, you still need to get permission. If it's a sculpture, in fact, you also need to get permission. So what happened in this case, even though the Statue of Liberty is no longer protected by copyright infringement, they'd actually taken the statue from the sexier statue, which is actually in Las Vegas. So the sculptor who created that version of the Statue of Liberty, and it's actually a brand new work, even though it's based on something else, he actually has copyright. That particular statue, they used, and 4 billion stamps, or whatever it was later, they realized their mistake. And so they should really have got permission from the sculptor in that instance. Next slide, please. Okay, so we looked at buildings and we've looked at sculptures. What if the sculpture is part of the building, right? So In this case, again, probably most people are familiar with Batman Forever, a film obviously about Batman. And in this case, what had happened was, yes, there was a location agreement, and they'd filmed this area to be the second bank of Gotham. However, here, what the argument was, that there were certain sculptural elements to this building, and they were actually outside the building. However, the court said that they were part of the architecture. So even though the sculptor, if they were separable, could have, could have brought an action, the court said, no, not in this case, because it's part of the building, therefore the public display exception applies. Next slide, please. Now, I mentioned earlier on about moral rights. So we've said, okay, buildings, sculptures, part of buildings, not part of buildings. Now here, is everybody familiar with the film Devil's Advocate? Well, anyway, Devil's Advocate was a film, and it had a scene in there involving a particular sculpture which actually came to life. Now, the sculpture was based on a sculpture which is actually on the Washington National Cathedral. And, it's a religious piece. It's a very significant piece, a very famous piece. Now, what had happened was, in the Devil's Advocate film, they took the sculpture, created another version, and made these figures in the sculpture come to life. And they were doing things that obviously were never intended by the original sculptor, and obviously quite offensive in terms of what had happened. Now, there was a preliminary hearing in the US, and they actually settled, and the DVD version had to be edited with that taken out. So the next slide, please. So just to summarize on buildings, because they're off, very, very, I get a lot of questions about these. So generally, there's a freedom of panorama. So you can reproduce buildings which are on public display. What you've got to remember, so for example, you can have the Eiffel Tower. You can even blow up the Eiffel Tower, which they did in Call of Duty. But what you can't do, because there are these exceptions, what you can't do is actually reproduce the lighting display at night time on the Eiffel Tower, because there is an exception, because this is a different aspect of the Eiffel Tower, which is a different copyright in relation to the building. So yeah, and moral rights, just remember, so even though there are certain things that you think are fine, sometimes there can be something else. So it's always good to check these things, research, etc. Next slide, please. Now, the other big area, obviously, is cars. People love putting cars in games, and I wanted to make you understand, well, what protects cars? Because people say, oh, why, what is it that's infringing? Cars are usually protected through design protection, and it's usually these features which are on the car. And this is a really, really interesting case, if you like ice cream. And I don't know what it's like in Poland, but in the UK we have ice cream vans. People go around and selling ice cream through these vans, and they're usually decorated in a certain way. And there's actually one main company that does this, called Whitby Specialist, based in Yorkshire. And what happened in this case was that company, Whitby, had been asked by Yorkshire. It was actually a family business who used to sell ice cream and thought, hey, we can make ice cream vans. Because ice cream vans aren't actually made in one go. It's just the paneling around it and the various features that you put on them. So it's actually a Mercedes van, which is then changed. Now, what happened in this case is the defendants got Whitby to make a van for them, and then they copied the whole thing and started making several of these. I think they sold 30 before the other company found out and said, right, now we're going to take you to court. And the court said, they'd copied specific things like, the ice cream cones on the van and, various branding on the back and things like this. And people do this in games. When you say, right, okay, they say, Nav, what can we do with the car? How different does it have to be? And you've got to be careful, because cars have these, sometimes they're protected by registered designs. Next slide, please. Now, really famous cars it's even more complicated because in this case, because I talked about registered designs because they represent certain parts of the car, but with certain things they can get trademark protection. Now, there was a series back in the 80s called Miami Vice, and there was a guy who used to create the cars for that particular series. And he created these replica Testarossas and Daytona Spiders. And he thought, these are cool, why don't I start selling these? So he ended up selling these, and the court decided no, he couldn't do this because the shape of these cars was so distinctive, it had secondary meaning in the eyes of the public. People would be confused that these cars actually are Ferraris. So he lost. So there's just an example, because people love putting Ferraris in games. I mean, it's been going on for years. Next slide, please. And then the other one is, military vehicles. Often this comes up. People want to make war games, and what can they do with vehicles? And you've got to look at the toy industry as well. I mean, they've had issues like this before as well. So in this case, General Motors and Lannard Toys, this was a Humvee, and this was their version of a Humvee. And the grille design on the Humvee was actually a registered trademark that belonged to General Motors. So General Motors sued this company and won, saying, well, no, you can't. You need a license from us. And then we had a recent case with Bell and EA. And EA obviously have been in court many, many times. And sometimes what they do is they argue that actually, in this case, the use of these helicopters is purely descriptive. We're not there to say that, you're buying this game because you want to be in this helicopter. I guess, when games are based just on one helicopter, that's the kind of endorsement that people would expect. But the court said, no, that's not right. I mean, Bell has various trademarks registered. AH-1Z Viper, this one here, is actually a registered trademark. They said people know these days that, there are licensing deals. And that realism is part of that. And so they lost. So including that helicopter without permission was not allowed. Next slide, please. And what about characters? So this is the main, this is what people mainly make games. And there's always some crazy character that someone comes up with or some unusual thing. But when you're looking at very simplified characters, what is the case? And here, we had a game by Konami, and Konami, and this is actually a Korean case, and Konami sued this company, Neepal, for their game, saying that the characters resembled their characters too closely. So the Konami characters on the left and the Neopol character on the right. And yes, they share some similarity, but what the court is saying, but when you're making cartoony baseball games, there's only, unless there's specific actual copying, that's a cartoony baseball game. So in this case, Konami lost, and Neopol were fine to carry on making their game based on these characters. Because there were differences, like in the shoes, there's lots of things. The face, the eyes are very different. So there's lots and lots of things which are different. And it's a baseball game, and a baseball game has a certain set of rules and the way it works. And the same has happened in pool games in the past and things like this. Next slide, please. And the other thing about characters is that if you're not creating your own characters, you get inspired, don't you, by what's out there, what's out there on the internet. And sometimes it's some silly things which you think, well, is that really protectable? Well, Nyan Cat and Keyboard Cat, who you may have seen on the internet, both of these characters were taken by the Fifth Cell and used in scribble notes. And they got sued. And they had to reach a settlement for licensing these characters in there. And characters don't necessarily have to be silly animals or people. In this case, Warner Brothers against Towel. When I talked about earlier on about someone making replica Ferraris, this guy was making replica Batmobiles. And the court said, yes, there may be some trademark stuff, but also they thought of the Batmobile as a character, and it was protected as a character. So you can see how, characters themselves can be extended. And so the Batmobile is now a character and has copyright. Next slide, please. And what about living people, personalities? And there's been lots of cases in the industry about this, and there are lots of cases happening at the moment. So one of the famous ones involves Lady Miss Kerr, who's a singer in D-Light, if anybody remembers that band. And she had an issue with this game, Space Channel 5. It's quite a hit on the Dreamcast, if anyone remembers. And that particular game, they had this character, Ooh La La. And Lady Miss Kerr used to say Ooh La La a lot, and things like this. So there were lots of things which you could say were similar about that character, but it actually wasn't her. And she was a news reporter, and there's been lots of talk about where they came up with this character, and frankly, a lot of the guys didn't even know who Lady Miss Kerr was. So in this case, the court actually held, no, there wasn't enough significant differences to say that actually this is, there were sufficient differences to say that actually this is a different character. On the other side, though, in No Doubt, there was actually an arrangement between Activision and No Doubt where they had a license to use No Doubt songs in the game and also their avatars. Now, what had happened was No Doubt objected because they thought their license only allowed them to sing their own songs in the game. However, Activision got them singing other people's songs, and they objected to that. So they went to court to try and interpret what this licensing agreement was about. And actually, they said, no, No Doubt were fine. They were right in what they were saying because the whole point of that game was to mimic these characters exactly as they are in real life. So by using them in that way, you were infringing their rights of publicity. Next slide, please. And these rights of publicity cases, obviously a lot of them are happening in the US, and the latest case that was decided was this one, Davis and EA. And there's been lots and lots of these cases involving, can you talk about this First Amendment right in the US? And here what they said was, again, it all comes down to what you're trying to do. If you're creating those characters as they are from the real world, putting them in your game, doing exactly what they do as they do in the real world, then that is infringement. Next slide, please. And there's lots of cases happening right now, and Lindsay Lohan is actually suing the makers of Grand Theft Auto because she thinks Lacey Jones is infringing her rights. Let's see where that case goes. Next slide, please. So we talked about sort of animals which are sort of made up, but what about real animals? This is really interesting. And this also shows you how the different rights within intellectual property can sometimes help you, but sometimes they can't. So here, this was a Japanese case, and it involved a game called Gallop Racer. And what had happened was the Tecmo used these real-world horses, and they got sued by the various race owners. The court held that because they applied the right of publicity test, that's what they were arguing against, the right of publicity. They said it didn't apply to animals, it only applies to human beings. And what about dead people? What about the estates of people who have died? Do they benefit? And particularly in the US and in other countries, including Korea, even after someone's death, their estate, their family can still sue for right of publicity. And this happened in the Godfather game. Now, in the Godfather game, there was this references to the Dillinger, which is actually references to a notorious gangster from the 30s. Now, the reason why they lost this case, the family, is because the statute predated the death of that particular individual. So if the statute was in force when the death had happened, then maybe they would have won that case. Next slide, please. So, and it goes on, what about objects and, and tattoos even? We've seen, most people probably know 12 Monkeys. Well, the chair that's used in 12 Monkeys is actually influenced by this particular drawing by an artist called Woods. And he successfully brought an action against, the guys who made 12 Monkeys. And tattoos, I mean, we've seen, the guy who created the tattoo for Mike Tyson successfully won a case against the guys who did Hangover 2. And in this case, which actually didn't get to court because, for various reasons, but it involved a tattoo involving a UFC fighter. And it was in the UFC game that THQ were distributing at the time. Next slide, please. And what about music? I mean, music is so important. Music is a very complex area. Again, we don't have time to go through all the aspects about music, but there's been some recent developments in music. People always ask me about sampling and all these other things, but what happened here was actually pretty crazy in terms of where the law is heading, if it is heading in this way. Well, let's see what happens on an appeal, but in this case, what happened was, most people probably know, there's a song called Blurred Lines. It's famous for various reasons, not necessarily because of the content of the song. And the family of Marvin Gaye sued them because they said that it infringed this song, got to give it up. Now, I don't know if anyone's actually heard both these songs together, but when you do, they're kind of, it's almost like it's inspirational. And what the court actually said, I mean, it was a jury case here, so they actually said, so merely by being inspired by a genre, making a song with the same sort of feel or groove, that's infringing. That can't be right. I mean, I'm waiting to see what will happen on appeal, but this could have lots of ramifications for game development if that is correct. Because most of the games industry is all about creating things which are inspired by a cool groove. So let's see what happens on the music cases. But I think that this will settle down eventually. Next slide, please. Now here's the most interesting part. So you're creating code, you've got graphics, but what really makes games different from every other art form is the fun element, is the gameplay, isn't it? It's all about the gameplay. And what I've said before, games are generally protected by copyright. I mean, that's the things, all the layers of things that we talked about. It doesn't protect ideas, which means that you can go along, I make a first-person shooter, you can make a first-person shooter. I want to set it in space, you can set it in space. There's lots of things you can do. But the closer you get to my idea in terms of how I've expressed it, the more, in terms of the expressive parts, you can rely on copyright to protect you. So over the years, I mean, this is Asteroids and Meteors. So Meteors, very old game, and Asteroids was made after. And in this case, what the court said was most of these elements were quite functional. To make this space shooting type game didn't actually infringe the rights of the previous game. But I mean, this was argued so many years ago, and things were very, very different then. Graphics were very, very straightforward. There was probably only so many ways you could do something. But what it did, though, it paved the way for cloning. Next slide, please. And over the years, we've seen all kinds of clones. So recently, we've had Tiny Tower and Dream Heights from Zynga. We've had this. This was actually in court involving Street Fighter 2 and Fighter's History, which they didn't succeed. There was Karate Champ and World Championship Karate. Again, they didn't succeed. We've had some recent examples with Ridiculous Fishing and Ninja Fishing, with Monument Valley and Skyward. So all of these things haven't been held to be infringing, or they didn't go to court, because it was just on that, what we're doing is just taking the idea. But has this really been tested? And, and what's been happening recently in the last couple of years is this is starting to be tested. Next slide, please. And this is a really interesting case because this is where they re-explored this whole thing about, the idea and expression. And again, they reiterated that the courts don't protect people's ideas when it comes to copyright. They protect their expression. But in this case, can anyone tell me which one of these is the real Tetris? It's actually, it's this one. Sometimes I look at it and think, is it that one? Is it that one? Because what they've done here, this company, Zio, had relied on the fact that they wouldn't be sued because they were making a Tetris-type game. But the problem here is they made it so closely to the original that the court had to hold that actually this was infringement. But there are certain things in the judgment which point towards it going beyond just the expressive elements, because in their copyright analysis, they actually looked at things like the ghost piece, the things that you see before, where it's going to fit, the preview piece, what piece is coming next, and these garbage lines about where it's going to drop to. So that's functional stuff. That should either be in the realms of patent, or it should not be protected at all. So did it open the door? Well, we'll see what happens. And if you go to the next slide, we had this case, Spirey Fox and Six Waves. And when you look at these games, they're very, very different. But here, what the court did, they started to look at the object hierarchy. So they started to look at things like, yes, there were bears in that game, but there were yetis in this one. That's quite similar. There were trees, so they were looking at the way the mechanics worked. So they went beyond what normally happens. But remember, this was only a first hearing. It got settled in the end. Whether this is how the law will develop, we will see. Next slide, please. And here's another interesting case which has come up, and this hasn't been litigated just yet, but last year, Glue released a game called Deer Hunter 2014, and what they've alleged is this game called Killshot has just taken everything about that game and replaced it with their own graphics. But the interesting thing about this game is that they've miscategorized the weapons in the same way as they're miscategorized in the Deer Hunter game. So clearly, someone has been looking at a game very closely, but we'll see what happens in court. And then coming towards the final slide. Next slide, please. And this is just hot off the press. I mean, these cases, it's just a couple of months old, so it has been filed, but we'll see what happens. But there's a game called Soul Clash, which is actually a game which is, has been out for a while, but it hasn't been marketed internationally until now. There's another game called Heroes Charge. And Heroes Charge has been doing phenomenally well. I mean, they did a Super Bowl ad, I think, for about $2 billion. And basically what's happened is they've said they've taken far more than just the idea. They've taken all kinds of things in terms of this game. And when you actually look at them side by side, that you can see that it very, very closely resembles the other game. So let's see what happens with that one. And I think I'm coming towards the end of my time. So just the next slide, please. So yes, sorry to be so, it's a whirlwind tour, but there is just so much. I mean, each of these things we can explore in their own separate lectures. So do we have time for questions?
We do have the time for questions. So please raise your hand if you have any questions. We have a time, but we don't have a questions.
Oh, there's a question.
Okay.
Hi there. At the end of your speech, you mentioned that there was a lawsuit filed from Lilith Game against Heroes Charge. But I know that Lilith Game, the first game, was actually also sort of like got their ideas from Dota, Defense of Ancient, the Blizzard. So what is the relationship between them and Blizzard?
So what I didn't get time to mention was Blizzard have now brought an action against Lilith Lilith are suing Ucool, which make Heroes Charge. Blizzard are suing Lilith, but they're suing them because they say their characters, not the idea, because the games are very different. I mean, Warcraft is a very different game from Heroes Charge or Soul Clash. They're suing them about their characters, and their character design looks very similar.
I would like to ask about parodies. How could you use some, for example, characters from other games in your game, but make fun of them a little? Is it legal?
Oh, parody. Okay, so again, because of the length of time that I have, I mean, yes, you can put characters in your game, and you've seen that there are certain types of defenses that you could try and run. One of the things that has recently been introduced, particularly in the UK, is the concept of parody. It hasn't really been tested in the UK. In other places where it exists, it has been tested. Usually it involves doing something which is a pastiche, a humorous thing. It stems mainly from when the Berne Convention, which actually deals with copyright, was created. Particularly with the French country, countries like France, they wanted to have these things for caricature and etc. There hasn't been any examples in the games industry where it's been tested. But yes, that defense is available. But there's a line that you need to be very careful that you don't cross. So it has to be done with very, very careful thought in terms of what you're trying to do.
Thank you.
So my question is, how do you see a negative ruling in one of these cases impacting, say, mobile, which is built completely around, copying, but with a difference? Because some of these cases that you mentioned, the differences are very vast, and you could actually say parody, inspiration, or whatever, but in the mobile market, it is built a lot around reskinning other ideas.
Well, I mean, that's a really good point. And I think the Spire Fox and, involving Yeti Town and that case, that was all about a situation where you think they're very different, but they've taken the game mechanics. And like I said, that case got settled. But in Europe, a similar case has come up, but in business software. And they firmly went back to the idea to say, well, look, functionality, anything to do with functionality cannot be protected by copyright. So unless they get a patent like they did in the Sega case and things like this, for effectively a functional thing, it wouldn't work. So I think the law will develop and get back to where it should be. The problem is that when you get something like a Tetris clone, which is almost identical, it's very difficult for a court not to grant a success on the infringement. Thank you.